Dear student, I am going to dictate you page number 14 of Ccsc. Speed would be about 100 word per minute. Start. Constitution seeking appropriate direction to the first respondent, State of Bihar, to prematurely release him on ground that he has been in custody for 24 years without grant of remission or parole. Remission Board rejected petitioner's application for premature release twice, held it would be appropriate if Remission Board reconsidered petitioner's application for remission afresh, considering reports of police and other authorities post prison record of petitioner remissions earned, including that which is earned for good conduct, his age, health condition, family circumstances, and his potential for social engagement in a positive manner. With benefit of new report, Remission Board may reconsider application for remission given the long period of incarceration already suffered by writ petitioner and his age. Remission Board should endeavour to consider the application at the earliest and render its decision writ petition allowed. Section 438 Anticipatory Bail Grant of Respondent was a proclaimed offender and sought anticipatory bail from High Court. Proclaimed offender not entitled to anticipatory bail. Of course, in an exceptional and rare case, Supreme Court or High Courts can consider a plea seeking anticipatory bail despite applicant being proclaimed offender. Given that the Supreme Court and High Courts are constitutional courts, however, no exceptional situation arises in the instant case. Respondent, without first successfully assailing the order declaring him as a proclaimed offender, could not have proceeded to seek anticipatory bail. Looking to the factual premise, respondent's application under section 438 should not have been entertained as he was proclaimed offender. High Court erred in granting anticipatory bail to respondent. Impugned order of High Court set aside respondent to surrender before court concerned and may seek regular bail which will be considered on its own merits without being prejudiced by present judgment. Section 438 Anticipatory Bail Grant of At much like bail, the grant of anticipatory bail is to be exercised with judicious discretion. Factors illustrated by Supreme Court through its pronouncements are illustrative and not exhaustive. Undoubtedly, the fate of each case turns on its own facts and merits. Section 439 Bail for offences under sections 302 IPC. High Court granted regular bail to respondent number 1 in trial proceedings pending before City Civil and Sessions Judge, Bengaluru. Cancellation of bail. Supervening circumstances developing post the grant of bail, such as interference in the administration of justice, abuse of concession of bail, etc., which are AVERSIBE to fair trial and would warrant cancellation of bail, applying the prematures as explained in this case to facts and circumstances of the instant case, there exists prima facie proximity between grant of bail to respondent number 1 and an emboldening opportunity for him to win over the witnesses. Respondent number 1 therefore does not deserve to enjoy concession of bail at least until all the crucial witnesses are examined. Privilege of liberty extended to him, thus deserves to be withdrawn for effective, fair, just, and unbiased conclusion of trial. Unusual and supervening events that have happened post the grant of bail to respondent number 1 do make out a case for recalling of witnesses for effective, fair, and free adjudication of trial. Conclusion. Constitutional powers under Article 142 of the Constitution read with Section 311 of the CRPC invoked for directing recalling of witnesses for their further cross-examination to reach effective decision in the subject trial. Bail granted to respondent number 1 cancelled. Impugned order of High Court granting bail to respondent number 1 set aside. Respondent number 1 to remain in custody till conclusion of trial or till Supreme Court released him on bail in changed circumstances. Stop.